Welcome everyone to today's webinar on how to dismiss an employee fairly. My name is Neelam Afzal and I'm an employment solicitor at Wildings. We've got quite a lot to cover in today's webinar for the next 30 minutes, so I strongly encourage that you take some notes. After the webinar, you'll be able to download the presentation slides together with a fact sheet. We're also recording this webinar, so the great advantage to you guys today is that you'll get a link to the webinar and you can go through the webinar at your own pace. At the end of the webinar, there is a 10-minute Q&A session, so I will try to get through as many questions as you want to put forward. There is a chat box, so you can type in your question, just hit the send button. If there's any questions that I'm unable to answer because of time constraints, I will come back to you offline. I've got email addresses, so I can email you your responses. I'm more than happy for you to contact me. My contact details are found on the first screen that you should be able to see. And you can discuss anything any employment matters that you've got or anything that I've covered today, and we can have an initial discussion. We've also got our website address there, so you can have a look at our website and look at the range of services that we offer employers. We are running these webinars regularly, so if you've got any topics that you'd like to hear about, please do email me. And please also, I'd be really grateful if I could also get your feedback following today's webinar. So we're going to move on to the next slide, which is in this webinar what we're going to cover. So who can claim unfair dismissal, the 2-year qualifying period, automatic unfair reasons for dismissal, what is a dismissal, 5 potentially fair reasons for a dismissal, the reasonableness test, looking at the substantive and fair procedure, remedies and practical advice for your business. So we're going to start off with who can claim. And it's an employee. Now, that looks like an obvious question, but it's not always straightforward. And there is a number of cases in the media where the courts have discussed this very issue. In cases you may have heard of, Uber, Pimlico Plumbers, where the courts will go behind the documentation, so looking at your contracts of employment, but look at the facts of the situation and decide whether the individuals are employees or genuinely workers, casual workers, agency workers, or self-employed. And the reason why this is so crucial is it determines what employment rights individuals have, because it's only an employee who can bring a claim for unfair dismissal. And there is a definition in the Employment Rights Act. An employee is someone who works under a contract of employment, but the definition in the statute is not clear enough. So what the courts have done is they've devised tests from case law which they apply to give the fact scenario. So what the courts will do is they will look at whether the individual carries out the work personally. So if it's an employee and the employee is carrying out the work personally, if there is mutuality of obligations between the two parties, which means that the employee is required to attend, perform his or her duties in return for a salary, and can't refuse to attend. And then we have employees who have control over the work. So the employer has to have control over the work that the employee does. And there are some exclusions to employees who can't bring claims for unfair dismissal. So employees who have brought their claim out of time. Now, what this means is that if an employee has 3 months to register the claim with ACAS, and then there's a specified period by which they have to register the claim with the Employment Tribunal. Now, if they present this claim outside of this time period, they won't be able to pursue their claim for unfair dismissal. But there are some exceptions to this, and the tribunals will apply some particular rules. Employees who are working under illegal contracts cannot pursue claims for unfair dismissal, and an example being somebody who's here in the UK who doesn't have employment status but is working. So that would be an illegal contract. And then there are the obvious employees, individuals who are not who are casual workers or agency workers or self-employed who can't bring these claims. Employees who have signed a settlement agreement or a COT3 agreement are barred from bringing a claim for unfair dismissal. Now, a settlement agreement and a COT3 agreement is an agreement restricting or compromising their right to bring a claim for unfair dismissal. Now, employees are also prevented from bringing claims under estoppel. And what this means is that the employee who has already lodged the claim with the Employment Tribunal cannot bring the claim because it's either been struck out, settled, or withdrawn. So those are some of the exclusions where employees cannot bring the claim for unfair dismissal. Now, we've established who can bring a claim. We need to look at what the requirements are. So it needs to be an employee. We need to then look at the qualifying period. So for an employee to bring a claim, they need to be employed for 2 continuous years, and that's usually calculated from the date they start employment to the date their employment has ended, and it's often referred to as effective date of termination. So you simply look at the contract and you work out the period of continuous employment. If there is a break in their employment, what the tribunals will do is they will look at the facts, and there are some special rules that are applied, but that's outside the scope of this webinar today. Now, back in April 2012, it used to be 1 year service. They've changed that, so now an employee needs 2 continuous years. There are some exceptions to this rule. So in certain circumstances, employees don't need to have the 2-year qualifying period. And these are just some of the examples that I've provided in this slide. We have employees who are dismissed for pregnancy or maternity related dismissals, dismissals for trade union reasons, selection for redundancy, which is either based on the above, but then we have other examples, for example, employees who have asserted a statutory right such as parental leave and they've been dismissed, or they've exerted a health and safety issue, or they've made a protected disclosure, i.e. whistleblowing. So those employees in those kind of situations they don't need to have the 2-year service. So now that we've looked at eligibility, we need to have a look at a dismissal. So there needs to be a dismissal for the employee to bring a claim for unfair dismissal. And a dismissal is either a termination by the employer, where the contract of employment is ended with or without notice, or a fixed term contract which comes to an end, where the contract's not been renewed, or constructive dismissal, where the employee terminates the contract under which they're employed with or without notice due to the employer's conduct, and it's usually unreasonable conduct. There are cases where there's no dismissal. So for example, a resignation. This is where obviously the employee resigns, but you need to be very careful that that resignation is not terminated in the notice period. So for example, if an employee is working out her notice period and the employer dismisses her, that could potentially give rise to a claim for unfair dismissal. Or the employee resigns as a result of the employer's conduct in the notice period, that could give rise to a claim for constructive unfair dismissal. Another example is termination by agreement. So this is where there's mutual consent between the parties. But again, it's important as an employer that you do not apply any pressure on the employee to resign, as this could lead to a claim for constructive unfair dismissal. And finally, termination by operation of law. So basically what that means is where the contract is frustrated, where it's impossible for the parties to perform that contract through no fault of either party. An example of this is where an employee is sentenced to a term in prison and therefore can't perform that contract or the duties under that contract. So moving on to the 5 fair reasons, we have capability, qualification, conduct, redundancy, breach of statutory duty or other restriction, and some other substantial reason, which is referred to an SOSR. Now there is an overlap sometimes between these fair reasons. So you could have somebody who's got a conduct issue and a capability issue, but it's very important as an employer to identify from the outset which reason you are using, because you can have more than one, but you need to identify the complaint and what the conduct is. Up until the 6th of April 2011, we had retirement, which was potentially a fair reason, and the default retirement age at 65 was abolished. So it's very important as employers out there to ensure that your handbooks, your employee handbooks are up to date and your contract of employment are also up to date. Simply because I've come across a lot of contracts still to date who refer to default retirement age in their documentation, and that went back in 2011. So when we're looking at capability or qualification, so a capability dismissal is where the employee is not able to do his or her job because of 2 reasons, and provided that the employer has followed a correct procedure, it will be fair to dismiss the individual. Now, when the tribunals look at how to measure capability, they look at the employee's skill, aptitude, health, or any other physical or mental quality. And the capability must relate to the work that the employee is employed to do. So in practice, capability dismissals fall into two main groups. Now the first is dismissal because of the employee's performance. That's where an employee is failing to reach the standards of work that's expected of them, and underperformance of the role. Secondly, there is a dismissal because of the employee's ill health. Now, the tribunal will expect an employer to manage poor performance and illness in different ways. So, for example, it is okay for an employer to warn an employee that they should improve their standards of work, or else. But it's not reasonable to tell an employee, get well, or else. So you need to ensure that you've got capability separated and whether it's illness. Capability reasons should be clearly identified and managed properly. Now, an employer needs to consider whether or not an employee is inherently incapable, i.e. can't do the role, or is not capable through laziness, negligence, or perhaps sheer stubbornness, will not do the role. So you're differentiating between the two, cannot and will not. And with the will not scenario, you are looking at a conduct issue as opposed to a capability issue. So moving on, in relation to qualification, a qualification dismissal is, and I'll give you, there's a number of examples, but one of the examples that comes to mind is, let's say you've recruited someone and it emerges when they join your company, they don't have the necessary qualifications. So in that kind of situation, you've got a capability dismissal because of qualification. So we're going to look at the second fair reason, which is conduct. Now, with conduct, it's one of the most common reasons. I'm sure in your businesses you've come across conduct-related dismissals. Now, it may be a single act or a serious act of misconduct. Now, if it's a serious act of misconduct, it's usually termed as gross misconduct, or a series of acts which are less serious. So, and we've got some examples in the slide. Now, these are only a few. I've seen handbooks with a lot of detail and a list of misconduct issues and gross misconduct issues. So in relation to misconduct issues, these include, for example, persistent lateness, unauthorized absence from work. With gross misconduct, they could include theft, dishonesty, violence at work, alcohol or drug abuse. But be careful that if the alcohol or drug abuse is an illness, you need to look at that very carefully to ensure that you are following a different process. So when we're looking at misconduct and gross misconduct, as I said, that's a list with some points, but your handbook needs to ensure that it says that the examples are not exhaustive. You also need to look at misconduct outside of the workplace because it's becoming more important where employees are outside of the workplace and their conduct can bring your business, your company into disrepute and damage the reputation. So ensure that you have good policies in place for conduct outside of the workplace. In addition, social media policies, we're all using social media to a different level. We're on Twitter, LinkedIn, Facebook. So you need to ensure that you've got a policy on how to manage your social media, and particularly if employees are posting information on social media sites which can damage the reputation. And again, those kind of examples fall into conduct-related issues. So we're going to look at the third reason, redundancy. Now, redundancy applies to a dismissal where it's wholly or mainly attributable to business closure, workplace closure, or where there's a reduced requirement for employees. So we're going to consider later on in the slides the reasonableness of redundancy and the procedure, but we're going to look at the fourth reason, which is statutory restrictions. So this is where the employer can dismiss an employee in the circumstances where their continued employment would be illegal. Now, I used the example earlier on of somebody working in the UK without any immigration status. Another example is a bus driver who's disqualified from driving, and he may be fairly dismissed because he's solely employed to drive a bus, and that would be illegal. But if you're looking at a driving ban, before dismissing the employer should consider the duration of the ban and whether the ban affects all or part of the employee's work. So if it only affects part of the employee's work, that employee can be redeployed into another role within the business. So it's important to look at alternatives that are available to the employer. Moving on, we're going to look at the fifth reason, which is some other substantial reason. So it's referred to often as SOSR. It's a catch-all reason, and there are a variety of cases on this, but the two most common cases are because of business needs and pressure from third parties. Now, we've got two examples on the slide. So in the case of Tregarnan, the employee was dismissed for boasting about her sexual exploits, which caused disharmony amongst her colleagues. And what the tribunal found in that case was that the dismissal was fair and it fell within the reasons of SOSR. In the next case, Scott Packing versus Warehouse Housing and Co. Limited, this was where a major client had threatened to withhold further contracts unless a particular employee was taken off that contract. And what the tribunal found was that, yes, it was an SOSR and fell under this reason, but the tribunal went a bit further to look at the reasonableness of the decision. And what they suggested was, would it be possible for that employee to be redeployed or provided with an alternative role within the company? So they look at the size, the resources, and the administrative process of the company to see if there's any other alternatives available. So those are the 5 fair reasons where an employer can dismiss an employee. So we're now going to have a look at the reasonableness test, and that's a definition under Section 98(4) of the Employment Rights Act. Now, it's quite a wordy definition, but what we've done is we're going to move on to the slides where we break down that definition to give you an overview of what test the tribunals will apply when they're looking at reasonableness. So moving on to this next slide, we've got any claim for unfair dismissal must go through a 2-stage test. So the first part is a substantive fairness test. And what the tribunal will do is they will look at whether the dismissal is within the range of reasonable responses for the employer to take relating to that particular type of conduct. And then they will look at the second part of the test, which is a procedural fairness test, whether the employer has used a fair procedure before the employee's eventual dismissal. So when we're looking at the substantive part of the test, the first part of the limb, we're looking at, it's an objective test. And what the tribunals have to decide on is whether the employer's decision to dismiss the employee fell within the range of reasonable responses that a reasonable employer in those circumstances and in that business might have adopted. So for the purposes of this test, it is irrelevant whether the tribunal or not would have dismissed the employee if they had been in the employer's shoes. The tribunal must not substitute its view for the view of the employer. So the tribunal can't say, well, actually, I would have done this in this situation. The tribunal can't substitute their own view. They've got to look at what's reasonable, that's open to a reasonable employer at that particular time. Now, the test applies to both the decision to dismiss and also to the investigation which leads to that decision. So this means that the issue for the tribunal is not whether they would have investigated things differently, but whether the investigation itself was within the range of reasonable investigations that a reasonable employer would have carried out. So they look at the main part and they also look at the investigation, so the decision itself, but also then the investigation. And in particular, the tribunal must assess the reasonableness of the employer's conduct, not the level of injustice to the employee. And the tribunal will take into account only the facts that are made available at that time. So if something comes about and they discover something later on, the tribunal will only look at the decisions of the disciplinary officer at the time, what facts were made available to that disciplinary officer. So the tribunal have also gone further in other cases where the employers have followed a tick box exercise, right? I've done this, I've got a statement off this person. What they will do is they will look at the particular facts. So all the cases are different and they are fact sensitive. So when we're looking at moving on to the next slide, the reasonableness of conduct. So we're going to look at each of the fair reasons, and we're going to look at the test that's applied under reasonableness and the test then that's applied under the procedural element. So in relation to conduct, this is a key case, British Home Stores against Birchall. And this is applied in conduct-related dismissals. So cases of, let's say, theft, violence, gross misconduct. And what the tribunal will look at is at the time of the dismissal, whether the employer believed the employee to be guilty of the misconduct. And at the time of the dismissal, the employer had reasonable grounds for believing that the employee was guilty of that misconduct. And then this last bit of that test is at the time that the employer formed that belief on those grounds, that it carried out as much investigation as was reasonable in the circumstances. So that the employer has to form decide whether they believe the individual is guilty, whether there are reasonable grounds for believing that employee is guilty, and that they've carried out a reasonable investigation in the circumstances. So the test that they apply is an objective one, and it's of a hypothetical reasonable employer, whether in dismissing the employee, the employer has acted within the range or band of reasonable responses to that particular misconduct found of that particular employee. And an example I'll give you, let's say somebody's coming into work and they're persistently late. Now, we've already determined from the earlier slides that that's a misconduct issue. Now, let's say the employer goes on to dismiss that employee following a few events without going through a warning stage, a written warning stage, or a final warning stage. So it's likely in that kind of scenario that the tribunal will find that it's not within the band or range of reasonable responses that were open to the employer, because there was the option of giving them a warning, potentially a final warning, before the dismissal. Now, when we're looking at the next slide, we're looking at the procedure. So it's recommended that in your handbooks that you have a separate conduct and capability procedure. Now, you start off on some, not all cases, but some cases with suspension. Now, this may be because of gross misconduct. So let's say there's an assault and you've had to suspend someone, but you need to look at what the conduct is, the seriousness of the conduct, and have a good reason. For example, you may be concerned that the individual might interfere with witnesses, which will prevent you from carrying out a thorough and detailed investigation. So normally suspension is with pay and benefits, unless there is a contractual right to suspend without pay. And you should inform the employee in writing of any reasons why the individual is being suspended, and also whether they're permitted from attending the workplace. Usually what happens is the employer recommends that the employee doesn't attend the workplace and doesn't contact any witnesses or colleagues, so there's no interference. The next part to the procedure is an investigation. So what needs to happen here is that you gather the facts, you carry out a thorough investigation. For example, sometimes on the face of some fact, you can look at it and say, actually, it's really obvious. And an example I give, an employee caught fighting at work. An employer may look at this and say, well, actually, it's the employee's fault. I've caught this person fighting, but the employer should investigate it. Was there any provocation? Was it with a subordinate who started the fight or someone senior, and vice versa? So go further and have a look at the facts. Take statements from the individuals, from witnesses, and particularly a statement from the employee concerned. So moving on to the next slide, we're going to look at the disciplinary process. So the disciplinary hearing, you need to ensure that you've sent out a letter with the allegations. You need to provide copies of all the evidence in advance of the hearing, and make sure you inform the employee of his or her right to be accompanied. That's a statutory requirement that they should be informed of. Give the employee sufficient time to prepare for the hearing, and at the hearing, listen to the employee, take into account any mitigation, have an unbiased approach, open mind, and do not prejudge the issue. Make sure you consider all of the facts before you make a decision. And if there's anything during the disciplinary hearing that's fresh new evidence, for example, an employee can give you details of a new witness, you may then, what you would do is you would adjourn the hearing, go back to the investigation stage, carry out the investigation, and come back and then make a decision. And you can make that decision with a further reconvened meeting and followed by a letter. And you also need to inform the employee of his or her right to appeal. So once you've carried out the investigation, and you need to follow the ACAS code, what I would recommend that you have an employee handbook, and the handbook mirrors the ACAS code, but it's tailored to the requirements and the needs of your business, because every business is different. So just an overview: investigate the issues, inform the employee of the decision, conduct a disciplinary hearing, provide the decision in writing, give the employee the right to appeal. And I would stress that there's two really key important things that you do look at when you're conducting meetings. At the start of a meeting, explain to the employee all the complaints, go through the evidence that's been gathered, and give the employee the reasonable opportunity to ask questions, present any evidence he or she has, and call any witnesses. It's important to listen and consider your approach carefully before you conduct these meetings. Ensure that also your documentation is in order, that you've got minutes of meetings, and that all your correspondence, and you've notified the employee of all the various meetings at the right stages. Now, if you fail to follow the ACAS guideline, whether that's the employer or the employee, so the employee may not appeal, you may not send a disciplinary letter out. Well, how this affects the end result is that it affects the compensation. So there could be a reduction or an increase in compensation from 0 to 25%. So regardless, I would still recommend that regardless of the compensation element, follow the procedure, because if you don't follow the procedure, the outcome could be that the actual dismissal in itself is unfair. So we're going to move on to capability, and the tribunal will consider, when we're looking at the reasonableness test, the tribunal will consider the following factors. Now, I'm not going to go through all of them, but I'm going to pick out just a few. So make sure that your employee knows what's required of them. So if the employee is not performing, you need to tell them. Take steps to minimize the risk of poor performance. Look at training, support, proper appraisal systems. Use your probationary periods effectively. If you have in your contracts the right to extend probationary periods, ensure that you provide the employee with notice a week before. Have regular meetings, and explain the consequences to the employee for failing to improve. Give them a chance to improve, and set realistic expectations so that you're not setting the employee up to fail. And if failing that, consider alternative positions within the company. Is there something else that suits the capability of the individual? So those are some of the points that tribunals will look at. Now, where there is just one issue of poor performance, it's unlikely that a single act of poor performance will warrant a dismissal. But however, there are some cases where it will be reasonable to dismiss an employee for serious acts of conduct. So for example, a pilot or a nuclear scientist or a train driver, where a single mistake could lead to major consequences and warrant a dismissal. Now, moving on to the procedure for capability, I would recommend that you have a progressive disciplinary to encourage improvement attendance. Start at the lowest stage of a disciplinary action, offer training support, help the employee to meet the agreed targets, and if they don't, then obviously it will ultimately lead to a dismissal. Produce evidence of poor performance, conduct a proper investigation and appraisal, identify the problem. Inform the employee of his or her right to be accompanied to meetings. Now, when we're looking at ill health within capability, you need to be careful that you ensure that any dismissal on the grounds of ill health is not discriminatory. So otherwise, it could amount to a discrimination claim under the Equality Act. So in cases of ill health, ensure that the employee, you have early meetings with the employee, contact the employee through their period of absence. Don't nag them, but good, reasonable contact is recommended. Look at a medical investigation, look at getting reports from medical experts, look at occupational health therapists, and consider any alternatives and any recommendations that are made by medical treatment providers if the employee is unable to return to that particular role. Now, when you're looking at redundancy, the reasonableness, what the tribunals will do is they will consider whether you've warned and consulted with the affected employees and their representatives, that you've adopted a fair process for selection, so there's a good selection process and it's a fair process, and that you've taken as many steps that you needed to minimize the risk for redundancy. So potentially looking at redeploying redundant people within the organization. Now, moving on to the next slide, we've got the redundancy procedure. Now, once you've identified there's a redundancy procedure, you need to ensure that obviously you have consultations, that you notify the employees that they've been put at risk, that you minimize and avoid compulsory redundancies, have a good selection criteria, consider suitable alternative employments, but also then once you've identified the employees at risk, look at the severance terms. So you would need to have a look at whether under their contract, the notice periods, holiday payments, what's due to them under their contract of employment, because failure to pay and consider these could potentially result in a claim for wrongful dismissal. And then finally, give them the right to appeal. Now, we're going to briefly just touch on procedural unfair dismissal and reductions. Now, we had this case of Polk. It's a Court of Appeal case. There are situations where the employer has a fair reason and the employer is reasonable in dismissing the employee, but they have failed to carry out a fair investigation. So they've not followed the investigation process. Now, the employer will say to the tribunal, well, I've got a fair reason, and if I had followed that process of a fair investigation, then the employee would have been dismissed in any event. So what the tribunal found in this case, that it makes no difference. There would be a finding of unfair dismissal, but the compensation would be reduced to reflect the fact that the outcome would have been the same in any event. So Polkey is applied to all of the conduct reasons, all of the 5 reasons we talked about. Now, I'm going to very briefly just cover remedies. So it's important that obviously you follow the investigation process, but I would also recommend, even if you have employees that have less than 2 years service, ensure that you do follow good practice. It creates good morale within the companies to ensure that you are following a process. It also avoids any complaints and any discrimination claims. Now, where the tribunal finds that the employee has been unfairly dismissed, in deciding what award they give, they've got a range of options available. So reinstatement, re-engagement, compensation, which is a basic and compensatory award. Now, in relation to reinstatement and re-engagement, there's also loss of salary. So from the point the employee was dismissed to the point the employee was reinstated or re-engaged, there's the shortfall of salary, so they can make an award for that. There's also reductions in compensation. We talked about Polkey, failure to follow the ACAS guide. And the basic award is very similar to a redundancy calculation. A compensatory award is based on what's just and equitable, and there is a cap in relation to the amount that you can claim, which is currently stands at £76,574. So it's very important that you do follow your processes and you understand your processes, because the awards can be quite high. And there are other additional sums which can fall into this: stigma damages, which we've not talked about, and aggravated damages, which can increase those awards. Now, moving on to the last couple of slides, there is a fact sheet that you'll be able to download. It identifies practical tips to your business that you can use to avoid unfair dismissal claims. Just a couple of quick things I'll pick out of there: good management practices. Think about your approach. Think about how you conduct your appraisals. Be honest with your assessments. Use your probationary periods effectively. Do not bully and isolate individuals or excessively critique. Moving on to the next slide, we've got a few more. So keep good records, conduct appraisals. But again, this is available on the fact sheet. So I hope that we've covered everything very much in a nutshell today. And there'll be a fact sheet and the slides that you can download. Obviously, please feel free to have a look at our website and email me any questions. I have noticed whilst we've got a chat box at the bottom for questions, I can't see anybody's put any questions forward. It may be you're not comfortable on this forum, so what I would recommend, please feel free to email me directly, and I'm more than happy to go through your questions and have an initial discussion. I hope that's helpful to everyone, and please also, it'd be really good to have your feedback. So thank you for joining us today in the Wildings webinar on how to dismiss an employee fairly. Thank you.